Home again, the Court of Appeal has today delivered a damning interim judgment in the protracted legal battle between a group of Canterbury landowners known as the Quake Outcasts and former Earthquake Recovery Minister Gerry Brownlee. In short, the appeal court has ruled, and I quote, that the minister's decision to approve the recovery plan, under which nothing was offered for uninsured improvements, was unlawful, end quote. If you followed the case, you'll know what that means. If you haven't, it was originally a group of 45 uninsured property owners in Canterbury who were effectively excluded from the full weight of the government's red zone compensation package. Complicating the issue was that people who owned vacant sections couldn't have insurance. You can't insure bare land. Gerry Brownlee once again declined our invitation to appear on Checkpoint, but Grant Cameron says it's another court victory. He's their lawyer, and this one must compel the government to do a deal with the outcasts.
It's actually an interim judgment, but it has allowed their appeal from a decision of the High Court in Christchurch. Basically, it said that the minister had acted unfairly and unreasonably.
Unlawfully.
Yeah,
is the word that is used.
Unlawful.
Yes.
That's it, right.
Okay, in what respect, Grant, sorry to interrupt, in what way were the minister's actions unlawful?
Well, in the particular regard, the court has declared that the minister's decision, which approved a recovery plan, under which nothing was offered for the uninsured improvements owned by these landowners, that was unlawful in itself. But I think when you read the judgment, it also makes it clear that the Crown arguments that were presented to the High Court as justifying the minister's decision were all found to be either unfair or unreasonable or also unlawful.
So we're talking about former Earthquake Recovery Minister here, Gerry Brownlee, right?
Yeah, that's right.
Okay. What happens now?
Well, basically, I think the Crown needs to go away and have a serious thought. I mean, this group has effectively won in the whole High Court, Court of Appeal, Supreme Court. It had a knockback in the High Court, but now the Court of Appeal has said no. The Supreme Court judgment was clear. You have to go ahead in accordance with the principles outlaid there. So they've restated the principles. However, it's an interim judgment, and there's now the opportunity for the parties to go away and then come back to the court with their thoughts as to the appropriate remedy. And I think this is the time where the Crown needs to go away and seriously think about what it needs to do to provide justice to these people.
And there has been no determination from the Crown whatsoever to do that so far, has there? That's why
well, there's been a great unwillingness. I think Nikki Wagner is the new minister in charge of these issues. She's a pretty reasonable person, and I think by the time she comes to grips with these issues, she may see things in a different light. And
how many people are we talking about?
Actually, there's about 30 still affected by this.
Why has this dragged on so long and been fought through so many courts? Why has the Crown been so reluctant to settle what is, in fact, in monetary terms, a small settlement? Is there a precedent here that the Crown is worried about?
Well, if it was worried about a precedent, it has probably done entirely the wrong thing, because what we have now obtained from the Supreme Court and the Court of Appeal is even greater clarity about the limitations on ministers and their decision-making going forward. Had they not brought these proceedings, they may have had a position which was somewhat more open and flexible in that regard. So I think there's been a degree of almost defiance, that's certainly how the group would see it, that the minister wanted to be seen to be strong in his decision-making, and there was apparently no value to be seen in stepping back from decisions already made.
That was Grant Cameron talking to us earlier.